I want to talk about a recent Supreme Court decision concerning financial and property provision on divorce. The case of the poverty-stricken New Age traveller turned multimillionaire, whose former wife has appeared years after their divorce to claim a share of his subsequently acquired wealth. Unsurprisingly, it caused a lot of media interest, but it also raises an important point of legal principle on which my colleague Joe Miles advised. The case involved Miss Wyatt and Mr. Vince, who were married in 1981, having chosen what one judge called the New Age or Traveller creed and lifestyle. They subsisted largely on state benefits and separated after only around 2 years of marriage. Mr. Vince threw himself into life as a New Age traveller, living in an old ambulance that had been converted into a camper van and protesting loudly against nuclear weapons. There were apparently brief reunions of sorts at places including Glastonbury, Stonehenge, and a local authority travellers' site that the husband described as akin to a rubbish tip, and the couple didn't formally divorce until 1992. There was one child of the marriage, Dane, who was aged 31 and lived with Mr. Vince at the time of the Supreme Court judgment. At that time, Miss Wyatt lived with her daughter, Emily, born before she met Mr. Vince, whom Mr. Vince could nevertheless have been liable to support during a minority, and two adult children that Miss Wyatt had with another man after the marriage broke down. Miss Wyatt and the three adult children lived in a house that had been the subject of a local authority hazard awareness notice. Miss Wyatt was in poor health and subsisted on wages from non-continuous low-paid employment and benefits. She had enrolled on several degree courses during the marriage, but had withdrawn from them for reasons such as her childcare responsibilities, her financial situation, and Mr. Vince's apparent discouragement. Mr. Vince, meanwhile, and despite being described as the most improbable candidate for affluence, had enjoyed brilliant success in business after the divorce. He was the sole shareholder of a green energy company he started in around 1995, which had a value of at least £57 million in 2015. By then, Mr. Vince also had a second wife and a young son. In 2011, almost 2 decades after the divorce, Ms. Wyatt applied for financial provision from Mr. Vince, no doubt in part due to the wealth he had built up in the intervening years. It was not clear whether she had applied for such provision at the time of the divorce, notwithstanding Mr. Vince's previous lack of means, since the relevant documentation had not survived. She'd managed to secure nominal child maintenance in 1992, but had been unsuccessful in securing substantial maintenance for herself and the children during the 1990s, and it seems to have been accepted that Mr. Vince was not in a position to support Dane until the later years of Dane's minority. There was still, however, a period of around 14 years when Mr. Vince was becoming wealthy and Miss Wyatt made no attempt to seek support from him. Miss Wyatt based her claim in 2011 on the fact that she'd cared for the children without adequate support and often in conditions of poverty, albeit that both Dane and Emily had spent at least some time living with Mr. Vince. Miss Wyatt sought a better home for herself and her family, and a fund that she could use to maintain herself for the rest of her life, given her limited earning capacity. Mr. Vince responded to Miss Wyatt's 2011 claim by seeking to have it struck out altogether, so that she couldn't take it to trial, on the basis of the delay involved, and particularly that it prevented him from establishing that she had in fact made a relevant application at the time of divorce, and that it had been dismissed. A Deputy High Court judge rejected his application to strike out the 2011 claim, but Mr. Vince successfully appealed to the Court of Appeal, which had agreed that the claim should indeed be struck out. Miss Wyatt brought her own appeal to the Supreme Court, and in March 2015, all 5 deciding justices held that the Deputy High Court judge had been right all along, in that the claim should not be struck out. The case has been returned to the High Court for determination of the actual outcome. Lord Wilson gave the only judgment in the Supreme Court. He concurred with the Court of Appeal's conclusion that it was likely that no financial order had been sought by Miss Wyatt or made at the time of divorce. He rejected the possibility that a claim had been made and dismissed at that time, which meant that Ms. Wyatt was not prevented from making her application in 2011. Such a dismissal was, in the Supreme Court's view, so remote as entirely to be discounted, since in 1992 Ms. Wyatt was a young wife and mother. Indeed, then as now, the court had a very wide discretion to order a redistribution of property between divorcing spouses under the Matrimonial Causes Act 1973, in the light of various factors contained in the Act, but had to give first consideration to the welfare of minor children of the family. The court's power to strike out the relevant type of application is contained in the family procedure rules. They allow the court to do so if, among other things, it appears that the statement of case in question discloses no reasonable grounds for bringing or defending the application, or is an abuse of the court's process, or is otherwise likely to obstruct the just disposal of the proceedings. In the Court of Appeal, Lord Justice Thorpe had based his decision on the first ground, but he and Lord Justice Tomlinson also agreed with Lord Justice Jackson's argument that the second ground was met in addition. Lord Justice Jackson held that bringing an application with no real prospect of success, which he thought described Ms. Wyatt's 2011 claim, was itself an abuse of process, because the court was not able to give the sort of summary judgment in family proceedings that it could in other civil proceedings. A summary judgment enables one party to obtain a judgment in his favour without a full trial, but with consideration of evidence beyond the statement of case. The Supreme Court justices disagreed with Lord Justice Jackson, since they thought that the lack of ability to give a summary judgment in family cases like the one at hand was explained by the fact that the court was under a duty to give consideration to all the circumstances of the case, with reference to the list of factors contained in the Matrimonial Causes Act, when exercising its discretion. This duty might be said to reflect the distinctly paternalistic role taken by the courts in family matters as compared to other areas of the law. In the view of the Supreme Court, the duty would be inconsistent with an ability summarily to dismiss Ms. Wyatt's 2011 claim on the basis that it had no real prospect of success. Lord Wilson also disagreed that Ms. Wyatt's statement of case disclosed no reasonable grounds for bringing the application. Given that there should be no inquiry as to real prospects of success, it was false, in his view, to say that her statement of case disclosed no recognisable legal claim or no reasonable basis for bringing it. Even if it had been proper to ask whether her claim had a real prospect of success, Lord Wilson thought that it should have been seen as having a real prospect of modest success. The case has given rise to a fair amount of sensationalism, and it's by no means the only recent case in the area of relief on divorce to have done that. But it's important to appreciate the limits of what has happened in Wyatt and Vince. The Supreme Court decided, for reasons including fairly technical ones, that Ms. Wyatt's claims should not be struck out without being properly heard. That is not the same as deciding that she should be given precisely what she claims, or that any provision should be made at all. In fact, Lord Wilson specifically said that the £1.9 million award that she sought was out of the question, and identified several formidable difficulties faced by Ms. Wyatt in making out her claim that could eliminate it altogether. Those included the short duration of the marital cohabitation and the length of time since it broke down, the fact that the standard of living during the marriage, one of the factors in the Matrimonial Causes Act, could not have been lower, and the fact that Mr. Vince had not begun to create his wealth until 13 years after the breakdown, such that Ms. Wyatt had not made any contribution to that wealth. Lord Wilson also noted Ms. Wyatt's inordinate delay in bringing the application, which was not fully explained. He strikingly described it as a dangerous fallacy propounded by advocates of reform in this area, that the law always requires rich husbands to meet the needs of their ex-wives. But he held it consistent with the lifelong obligations of marriage that there was no formal time limit for bringing the claim at issue, unlike the situation with other civil law cases. And in my view, it is significant that had Ms. Wyatt brought a successful claim at the time of divorce, Mr. Vince could still have been supporting her even now. Lord Wilson was unsure that Miss Wyatt would ultimately succeed in showing that she had needs generated by the relationship that Mr. Vince should be expected to meet. But his lordship identified an argument that he considered potentially much more powerful, based on the court's obligation to consider the contributions Miss Wyatt has made to the welfare of the family, including any contribution by looking after the home or caring for the family, which is not limited to contributions made during the relationship. Lord Wilson's view is interesting because in recent years the judiciary have to some extent shied away from specifically evaluating the contributions of the spouse working inside the home, instead preferring that they be subsumed into the idea that marriage is an equal partnership and that there should be no discrimination against that spouse. Whatever amount Ms. Wyatt is eventually awarded and on whatever basis, there is cogency in the Supreme Court's conclusion that her claim should not have been struck out before trial, in spite of its difficulties. Lord Wilson described Ms. Wyatt's delay and her contributions as magnetic factors pulling in opposite directions that were worthy of investigation back in the family division of the High Court. The Supreme Court seemed to hope that the parties might be able to settle their dispute in light of its conclusion, but Mr. Vince has since given an interview reaffirming his determination that his former wife should get nothing, so this may not be the last published judgment in the case. It's tempting to suggest that he should have agreed to make some provision for Miss Wyatt before matters reached the Supreme Court, particularly in light of the legal costs that he will have had to bear on behalf of both himself and Miss Wyatt, but he's apparently determined to fight for what he sees as the only principled outcome. What are the implications of the case for other couples? Well, it highlights the importance of trying to reach agreement on post-divorce provision at the time of divorce, and having the court enshrine that agreement in what's known as a consent order, even if the couple don't seem to have any real assets at that time. The importance of holding on to key documents is also a vital lesson from the case. While a property evidence consent order might still be varied or even set aside at a later date, it would reduce the scope for a completely new application like the one in Wyatt and Vince. The Supreme Court's decision is also a reminder that English law can view a marriage as involving lifelong obligations, even where it has been formally dissolved via divorce. Whatever the true import of Wyatt and Vince, it seems likely that the law of provision on divorce will continue to sell newspapers, whether or not they give their readers a fully accurate picture.